Hey everybody, this is Josh Schachnow, Canadian immigration lawyer and CEO at Visto for another episode of the Canadian Immigration Pros podcast. Very happy to be joined today by Clinton Green, the principal lawyer at Green Immigration Law, the chair of the OBA as well. Clinton, thank you so much for coming on the show today.
Thanks for having me, Josh.
Clinton, can we just start with a quick introduction? Just as a quick preamble, we're going to be talking about some big updates, especially on the economic side. We're going to talk about LMIA-exempt opportunities, what employers should be thinking about. Before we dive in, can you give us a quick introduction, a little bit more about yourself?
Yeah, sure. As Josh mentioned, my name is Clinton Green, Canadian immigration lawyer, and I've been practicing exclusively in Canadian immigration for just about a decade now, having worked at some large firms and now operating my own firm. Immigration is my passion, and yeah, I'm very excited to be here today.
Awesome. We've got some good, especially economic focused topics to talk about today. The first one that I wanted to touch on was programs like ICT and Express Entry,
Okay.
especially because Clinton has a lot of experience on the corporate side. Maybe as a jumping off point, Clinton, can you talk about just high level 30,000 foot view? What have we seen happen at the ICT level? And if you want to mention anything related to Express Entry as well, or we can treat that as two questions.
Of course. The question is, what haven't we seen, right? When it comes to these changes, and so when it comes to the intercompany transferee changes, the most significant is that companies that would typically be able to benefit from an intercompany transferee now are not able to. Wherein the most significant change is that to be eligible for an intercompany, a company has to demonstrate that it already is generating revenue in two other countries. And so, before they can actually, benefit from transferring a foreign worker to Canada. What that means is there's a large company in X country, let's say Mexico, the US, or another country, has been operating for many years and has a related entity in Canada that has also been operating. Unfortunately, that company would not be able to benefit from the intercompany transferee provisions if that foreign worker is not also, from a free trade country, i.e., from Mexico, from Canada, from the US, or one of the few other countries where Canada has a free trade agreement. And that captured a lot of people, unfortunately, who wouldn't be able to benefit from intercompany transferee. Another major shift with the intercompany transferee program is that the companies now must have physical presence in Canada. There's some, limited exceptions to that, but you must have a physical presence. And so it's no longer the case where, you can transfer in worker wherein it's your operation exclusively is virtual. And if that worker is going to be working remotely in Canada, there now needs to be a rationale as to why that person is now needed in Canada. And much like what we've seen in the LMIA program, the justification of like a time zone difference, that will not be enough. And so there has to be, a good justification as to why someone would be working remotely in Canada. Sorry, go ahead, Josh.
I was just, even before we jump into Express Entry, this has already got me thinking. Most of my experience was with LMIA backed work permits. I didn't do a ton of ICTs. Can you talk a little bit like, is this change really hurting a lot of people and businesses? Because you have far more experience with it than I do. And I don't think I fully appreciated maybe some of our listeners who aren't immigration professionals themselves, or they just haven't done much ICT work. Like, this seems like a pretty big change. Are employers feeling this?
They definitely are feeling this, in high volume practices, these large companies, many of them would rely on the intercompany transferee provision. That's always the let's call it the old reliable. This is in many cases, many instances when a company is looking to transfer a worker. The first question is, how long has that individual been with the company outside of Canada? Because the first option we would like to explore is whether they could benefit from an intercompany transferee. looking at certain tech companies, for example, in the US, where they might have hired, individuals who are not from the US, for example, from India. And so these Indian nationals obviously do not benefit from a free trade agreement. And of course, are only, falling back on the standard intercompany transferee work permit. And so in an instance like that, you would want to be able to take advantage of the intercompany transferee. And what we know is that statistically, most work permits are actually under the International Mobility Program rather than the LMIA Temporary Foreign Workers Program. And so to answer your question, there's a significant impact.
Got it. Why do you think they made this change? My best guess has always been the fraud, in the sense that a lot of people might just like have a legitimate company or an illegitimate company abroad, and then they work there for a year. Maybe they've legitimately worked there for a year, and then they open up a branch in Canada. Bing, bang, boom, you can ICT. Do you think it's because of that? And then like it's kind of sad then if all these major companies are being punished for some fraud from, let's say, like smaller players. But yeah, I'd love to hear your thoughts.
Yeah, I would. Sure. I think the explanation for it would be to address fraud. And I'd wager that there's a small percentage of, or was a small percentage, intercompany transferees that were, almost from a family owned operation or small operation where someone would then transfer to Canada to be able to obtain a work permit and then get on a path to permanent residency. And it was, we've seen it in practice where instead of leveraging, let's say, the entrepreneurial program under the PNP because of how many years that would take, or getting an owner operator LMIA, which that's pretty much not in existence, right? People started looking at startup intercompany transferees, for example, to be able to bring them in and then transition to permanent residency. So we'd see that quite a bit. But to your point, it is unduly affecting other companies, large and, small, medium-sized enterprises, which per Canadian standards, if you employ 100 people, that is a small and medium-sized enterprise. And so I have many clients who operate in one other country. Maybe it's India, maybe it's a country in Asia, maybe it's Mexico, and large company employing enough, people and looking to operate in Canada or are already operating in Canada. And as a result, not able to now benefit from an intercompany transferee for, workers who aren't from the countries that have a free trade agreement with Canada.
Right. What would you have done instead? Because I kind of feel like ever since this happened, I feel like they're punishing too much good in order to, catch a few of those frauds. I wish they just processed the applications with a little bit more care, because I think given our economy right now, we need entrepreneurship and business investment and foreign investment more than ever. Right. So I look at this as a net negative. Do you agree? And what do you think might have been a better solution?
I definitely agree with you. I think that a better solution would have been to incorporate some of the changes that they've brought in, wherein you can demonstrate the onus is on the business to demonstrate that they have a legitimate operation abroad and a well-established business in Canada at minimum, right? Or so let's stay out of the startup ICT area for now, but looking at businesses that are operating in Canada, I think requesting more documents and evidence of organizational structure and, plans in Canada. I think that would have satisfied an officer that this is, a meaningful operation, a genuine business that is contributing to Canada quite significantly. And you don't, in my view, the idea that the company must have been operating outside of Canada and two other countries and generating revenue, that bar or threshold is just significantly high. And to your point, limits innovation and the business that you're going to see coming into Canada.
For sure. And the other thing I was talking about with someone else is like, I agree with you. Just increase the document checklist requirements a little bit. And with businesses, it's not rocket science per se, right?
No,
Send us your recent corporate tax return from Canada and from your home country. Bing, bang,
correct.
boom, right? Maybe there's a revenue threshold or something like that.
Correct. And look at what we did with the LMIAs, for example, in terms of looking at business legitimacy and ability to, satisfy a job offer. Those document requirements are helps demonstrate that the business is, operating and has been operating for X amount of time in Canada. There's no reason why we could not have incorporated that in the checklist, as you said, for an intercompany transfer. Still driving to the same point of curbing fraud, but encouraging against investment, innovation, and growth, business growth in Canada.
Absolutely. So let's switch gears. I do want to come back to other like LMI exempt solutions that people can turn to. Let's take a quick PR break and talk
Mm.
about Express Entry. How does this relate, if at all, with Express Entry? What have you seen lately? Anything notable on that front?
Yeah, I think when we're looking at expert century, so many changes, right? However, the ones that most affect employers and foreign nationals who are in Canada is the change regarding the LMIA, sorry, points for an LMIA job offer, which we know is going to come into effect in March, right? That that interacts with this limitation on the ICT, the intercompany transferee, because now companies that were, you know, as of fall of last year, no longer eligible for intercompany transferee were looking to possibly benefit from an LMIA, for example, to bring in a worker. Now they have to say to this worker, well, there's not necessarily a path towards PR for you because not only are we, you're not going to have points for having a job offer, which will make you less competitive. We also know that there are infrequent draws and the threshold or the scores required for someone to receive an invitation to apply has been, on the rise. And so we have a situation where Canadian employers who are looking to attract global talent are going to have more difficulty because when you're looking at competing for talent, these candidates want to know, well, if I pick up and move my life to Canada, the move in of itself is significant. I moved twice now, and I don't really wish it on anyone. It's there's some benefits, but it can be incredibly stressful on your family. And then
Sure.
I don't have children, so I can only imagine some of these workers who are moving with their families. It's a significant investment. The idea that you move to Canada and you don't know if there could be a way forward. And of course, we know legally you should only have the temporary intent, but when the employer is packaging, you know, an opportunity and trying to attract talent, that talent is looking towards the long term. And that means that Canadian companies are going to be less competitive in on the global stage, because why entertain that risk when maybe you roll the dice in the same way and try to go to a larger market? And so it's going to unduly affect businesses. How the changes on Express Entry are interacting with some of the other changes, most notably right now, the intercompany transfer
Yeah,
option.
and I see it as such a shame too, Clinton, right? Because like there might be a company, let's say like an incredible high growth company in the US, and they're thinking about opening that next big office, and they're
Correct.
considering Canada versus the UK versus, whatever,
Right.
right? Whichever countries. And
Right.
all of these things are just check boxes against moving that office to Canada, which is, again, as we said earlier, kind of what we need right now. I see this
Right.
as a negative for the exact same reason, which is, from my understanding, one of the reasons why they made this specific change is because of LMIA fraud. But again,
Mhm.
instead of fixing LMIA fraud, they're just going to say, okay, all the people who commit fraud, we're just not going to give you more points for express entry, which what does it do? It hurts all the companies you just talked about. And it
Right.
hurts all those people who have genuine job offers and LMIAs and who could be very valuable skilled talent to our
Correct.
country, which is a
Correct.
problem. Do you
Correct.
agree? Like, I still know enough people that actually did like the move of removing the 50 points because they're like, listen, so many people have fraudulent LMIAs that we actually should remove it. I
Mhm.
don't agree with that personally. What do you think?
Yeah, I agree with you in terms of the fact is you were to get to the root of the issue while still having a system that benefits the employers and the people who are participating in it, who are, well-meaning and also adhering to the laws and the condition. It's almost, you're punishing, a larger group based on the performance of a small segment of the population. And so what I would have said is just like, yeah, make changes to the LMIA program in terms of being able to better determine when there is fraud. What do our compliance provisions look like? Is there a framework for following up and ensuring performance has been met in X ways, and that the documents are not just accurate, but there's no fraudulent information or documents being provided, and so these are huge questions, and of course, it can be so simple for us to maybe opine on it, because there's budget restraints, etc. Look at the climate we're in, so it's a tough issue, but I completely agree with you that removing the points is almost putting a band-aid on something rather than actually finding a solution to the problem. Because if there's bad actors in this one space, those bad actors might find ways to shift to a new space.
Absolutely. For sure. So let's talk more positive. Let's talk about, we obviously can't change some of these changes, but what we can talk about is what can people or what can companies do, right? You talked about ICTs a lot more difficult,
Yeah,
PRs or express entries a lot more difficult. What are some other maybe LMI exempt or other good options for corporates or, skilled workers right now?
yeah, good question, Josh. And with the intercompany transferee, I guess, changes and it impacting impacting businesses so significantly, and not they're not being, an option now for LMI in many of these cases, because you want to be able to have this worker transition eventually to permanent residency, because there's not just consideration of the law and being able to maintain people's status in Canada, but the other piece is a significant consideration. This is the budget restraints of these companies if you have hundreds of foreign workers. And so although, in the last couple of years, I have helped companies, wean off of the LMIA, because I'm not a big fan of leveraging the LMIA. It should be a last resort. I
I
do
don't know who
know
is a fan. Yeah.
I do know that it has been used in a way as a crutch. I had a couple big clients that always saved maybe 60 to 70%. I helped them save 60% or 70% on their immigration budget by avoiding LMIA, so it won't impact our clients as much, for example. However, what some people are not doing. And so these are some of the options that I'm floating to my clients and have been floating, as I said, historically, these LMIA exempt options. And the most common one for me, and it's just an old reliable, in that I have not had any, let's say, any refusals or anything to that effect with this type of work permit. And it's underused, to be honest. And that's the C20 reciprocal employment work permit category. And this work permit category is great because it allows a work employer to bring in a foreign worker or to extend a foreign worker's work permit on the basis that it's providing opportunities for Canadians and permanent residents to work outside of Canada. And so this is the idea, or the reciprocity. The good news, however, is that you don't need to have a one-to-one ratio in terms of reciprocity. So if you only have, for example, 10 Canadian permanent residents out working at an entity outside of Canada, it doesn't limit you to only bringing in 10 foreign workers or extending the work permits of 10 foreign workers. And in fact, there's information in the policy that states that IRCC's policy that states that they're looking at a 75% ratio for a large program. And how they define a large program is a program where you have, I believe, 25 or more foreign nationals, right? And if it's a smaller program, that ratio does not apply, or the officer has the discretion to not apply that ratio. And in my experience, so long as you rely on that policy and it's a smaller program, especially if you haven't participated extensively, you would be able to benefit from bringing in foreign nationals, even when the ratio is, not as favorable as 75%. What
Right.
is important for these companies, though, is that the first stage or starting point is that this company has a global mobility policy and effectively speaks to the fact that employees in Canada and globally are able to transfer between offices. And this is important for companies that may only operate in one other country. So I have a client who operates in the US, for example, and then has offices in Canada for its non-US or non-free trade. Sorry, its employees who are not from free trade agreement countries or countries that have free trade agreements with Canada. They would not be able to leverage an intercompany transferee work permit for these workers, like Indian national, for example. And so the C20 provision comes into play here and works very well. This client, let's say they have 20 Canadians working in their office, and they do because the nature of Canada and US's relationship, we have quite a bit of Canadians working in the US. I'm now one of them. My partner is one of them. And so this is happening quite frequently. And so we help companies by mining their population, learning about which workers they have in Canada, workers are in the US or whatever country they're operating in, and how many of them are Canadians and or permanent residents, and then work back from there. And so long as there's a policy in place, and this is something it does not have to be a policy that's been longstanding. It can be a new policy. You have that policy, you have the numbers, should be able to obtain a work permit under the C20 provision. Another benefit for this provision is that unlike the intercompany transferee, this does not, there's no prevailing wage requirement. There's also no strict requirements surrounding, having, at least not yet, having a physical office, etc. So it can be a bit more flexible. Still, you'd want to, include some of it when guiding the client, or what I would say to my client is that still want to wish as many of the marks on an intercompany transferee that you would on an intercompany transferee on the C20, i.e.
Right.
having an office, having a manager that the person will report to, etc.
So I just want to confirm this because I've never done these myself. And I feel like, as you alluded to, probably extremely underrated and underutilized, and maybe most people don't even know about it. So are you saying if you're a Canadian company, you have an office abroad, and you have X amount of Canadian citizens or PRs working abroad, that basically gives you the ability to bring Y percentage of them, as you said, maybe up to like 75% or, roughly, into Canada, LMIA exempt.
Correct. Correct.
Wow. I feel like
And
this needs to be a PSA to especially a lot of the immigration professionals like me who, I mean, I don't do much of that work anymore anyways. But yeah, like you rarely really hear about this as an option online, on socials.
agreed.
Um,
Agreed. And what we've seen in the past, or I've seen in the past, like, what I alluded to earlier, the first step is can we leverage an ICT? And instead of looking at other LMIA exempt options, you may then go immediately to an LMIA. And there can be different, we may want to stick to the LMIA exempt option, especially in this climate.
Absolutely. Yeah. I mean, I don't think anybody submitted an LMI and said, "This is great. I can't wait to do it again." Right. So that was great, Clinton. Thank you for sharing. Any other LMI exempt golden nuggets like that you wanted to
Yeah,
talk about? Maybe not as golden as that first one, but yeah.
definitely. I think the other two really would be the provincial nomination or nominee T30 work permit. So effectively, a foreign worker who's been nominated by province and that nomination is employer specific or employer sponsored. That individual would be issued or should be issued a work permit support letter in conjunction with that nomination certificate. They can then apply for a work permit. This can be a great option for certain provinces. Maybe not some of the larger provinces where we're having some issues with, significant delays in processing times and delays in like selection and whatnot. Maybe that will change. However, still a great option to consider because much like LMIA, for example, if your company is looking to hire a foreign national who's outside of Canada, many of these provincial nominee programs provide for the employer to show proof of recruitment and that they've done their best to find a Canadian or permanent resident to hire. And, because they were unable to, they are then able to, support application for nomination. That, and in many of these provinces, you're looking at a processing time that might vary between 1 month and 4 or 5 months. In some ways, similar to what you'd see for a global township LMIA, so on the short end, but that the regular LMIA is high wage or low wage, you're looking at 4+ months for an LMIA. And so getting this nomination then allows them to apply for the work permit. But the benefit of applying even with that work permit support letter, getting this LMIA work permit is that the work permit, so long as it is, the appropriate tier, they benefit from the global skills strategy and as a result, a faster work permit processing time. Because still, if we had submitted regular LMIA, the risk is putting forward a work permit based on that regular LMIA. The processing times will be much slower than the global skill strategy work permits. So the LMIA exempt work permits that are, for the highly skilled individuals.
Very cool. Yeah, I hadn't thought of leveraging that combo, PNP nomination plus global skills strategy, because the first thing that popped in my head when you started this topic was,
Mhm.
okay, but then you got to wait for the PNP and then you still have to wait for the work permit. But like you said, if you can combine those, any specific provinces that you're seeing that are really prime for this, and or are you seeing companies adjust to this and like think about office locations in strategic provinces?
Yeah, so these are some. So in terms of your first part of your question, in terms of provinces where this is possible, I would say that you're looking at all the provincial nominee programs. However, when looking at the processing times, you're going to have faster processing times right now in like the prairie provinces, Atlantic provinces. Right now, British Columbia and Ontario are struggling with respect to their processing times. Still could be very much worth it. My experience with the British Columbia PMP is that although the processing times are, getting quite lengthy, the program is very reliable and has been very helpful for companies who are out there, especially a lot of my tech clients in the past that have been able to successfully get provincial nominations. Now, to your second question, this has been something I've been advising my clients for a couple of years, actually, to be more strategic about where the offices, where they're going to set up shop. And so I think we will start to see a lot more thought into where a company is willing to set up their operation.
Absolutely. And especially with, I mean, last week they announced some rural, more rural pilots. So like not
Correct.
only by province, but maybe even by town or community and stuff like that. So certainly more things to consider than ever before, right? For really any immigrant, and then also companies that want to leverage foreign talent as well. Any last options, Clinton, before we kind of wrap things up?
Yeah, the last option would be the significant benefit work permit, the C10. And, it can seem daunting. However, I think a well-crafted argument. So we are putting on our lawyerly hats or our hats as immigration consultants and drafting compelling arguments and putting, forward excellent evidence that demonstrate that a company bringing in ex foreign worker will result in a significant economic, social, or cultural benefits.
Do you have some
In my
examples? Like what are good use cases, would you say?
Perfect. Yeah. I think so. I'll share some examples from me in the past. Uh, there's different ways to approach this. Some people approach this from the perspective of this individual is, someone who is highly renowned in their field, almost extraordinary, very similar to like the O1 that you might see in the US, right? X publications, they've done these amazing works and they're contributing to this particular project. It's very specific, our narrow area. And that can be very helpful. The other way to look at it is the project, is the business, the work that's being done, is that a significant benefit to Canada or a certain community? And what role is that individual playing? And but for that individual participating, does that impact the ability of the business to carry out this project? And if so, is that going to impact, maintaining jobs, creating jobs? Does it have any far-reaching impacts for clients and other businesses in Canada? And so that's different ways to approach it. And so in the past, for example, I think one of my first significant benefits was a bus driver coming into Canada. And in this case, it's like, well, he's a tour bus driver. But what we did was look at the tour that he was supporting. And so collected data about the the I guess the areas in which this tour was going to be present, the impact to the local communities, whether that's the ticket sellers, but you're looking at the merchandise, the local economy that kind of gets like almost like a jolt because of this increased attendance in this immediate area, the cultural impact, etc. And as a result, because they're supporting that tour and it was critical and time sensitive, the LMIA would not have been practical in that moment. That is a serious consideration. Then, yeah, the application was approved. Similarly, when the other situations where individuals were not eligible or, any type of LMIA that were permitted, but there were significant projects, environmental projects, where, maybe it's drilling that's occurring and that's going to not lead to future benefits in terms of benefits for Canada, but immediate benefit from people being employed in the area. And so again, a significant benefit there. I've helped companies, for example, who are looking to bring in, high level marketing or even mid level marketing professionals who are part of a company where the work that they're doing is helping further a sector in a province. And then you look at the data around, well, how much does this sector contribute to the GDP, for example? How many people are employed here? With this marketing agency, are there potential clients they're looking to work with and that they are contingent, I guess, that relationship is now contingent on bringing in this worker and being able to make those connections, draw those connections, tell the story for the officer to make it clear what those significant benefits are. It's been highly successful. Will that continue at this climate? It remains to be seen. However, I think it's still a very viable route for many use cases.
Right. Yes. Super interesting. It sounds extremely subjective. Can you
Mhm.
talk maybe really quickly about if I'm another lawyer or consultant and I'm thinking about offering this as an option to my client? What am I looking for? Like, at what point do you say, you know what, yes, this is worth a try versus like, we're
Yeah,
kind of reaching here. I don't think we have a great chance.
yeah. Great question. So I think what I start with is okay. Tell me number one. You need to know your client. What do they do? Number very plainly, but then also, what is the impact of what they do? Are there any specific projects that are, quite high profile right now, where there's a lot of being invested? Whether there's any funding they're receiving that's kind of on the line. For example, we helped a independent gaming studio which needed to extend the work permit of a software engineer who was I found out that this software engineer was leading on a significant game that was going to be, the the differentiator between the business, I guess, being successful and not not existing beyond the next year. So asking those questions, driving down to the need, if you're able to find information about what's at stake, that will help guide you as to whether there's enough here to pursue this very discretionary application. And to your point, it being so discretionary, you also want buy-in from your client. And so it's important to advise them as to the risk in terms of it being such a discretionary application and getting that buy-in. They then partner with you to ensure that you have even more information that's needed. And so you get that initial question, those initial questions answered. I would recommend going straight to the C20 guidelines on the IMP on IRCC's website, specifically the exemption code list. From there, you look at how the officer is expected to assess an application, the criteria that they consider. Take those and then formulate them into a questionnaire to collect additional information from your client so that you're basically turning over all stones. And then from there, you then target and streamline your argument.
That's almost a great piece of advice for any other program too, right? Go check the guidelines, reverse engineer into a questionnaire. A great way to intake and kind of help
Mhm,
clients.
mhm,
Clinton,
mhm.
this has been great. I would say one of the things, a lot of episodes I do, I'm getting to have fun conversations about topics I know really well. And then once in a while I'll have a guest on where I get to learn about something that I really didn't have much idea about. And I feel like there was a lot of the latter in this episode. Talked about ICT changes, the reciprocal employment agreement, which maybe people have heard it here first, and now we're going to put it on the map a little bit. We'll have to see what kind of feedback. For anybody listening, please feel free to let us know what you think. Have you used it before? Have you not? The C10 work permit, the PNP plus global skills strategy combo. I think that's really good as well. So, anyways, I've learned a lot. This has been extremely helpful. If there are people or companies or aspiring immigrants out there that want to get in touch or learn more about you, where do you recommend that they go?
Thanks for having me. But yeah, in terms of where people can find us, so greenmlaw.com, so www.greenmlaw.com, and also on LinkedIn. And you can always find me as Clinton Green or Green Immigration Law PC and follow us there for updates. And of course, if you are from the newer era, we're on Instagram, so Green M Law as well.
Awesome. Clinton, thank you again for coming on the show. We're going to have links to those in the descriptions, the websites, the socials, all that kind of stuff, whether you're watching on YouTube or listening on your favorite podcast platform. Clinton, thanks again for coming on. Really appreciate it.
Thanks for having me, Josh.